Are we ready, Caitlin?
Yeah, so, well, I mean, we can take a few minutes to let the people keep filtering in, but yeah, people are starting to show up.
Okay, very good.
All right, Lori, I think we're good. Gratitude.
All right, we'll get going. Good morning, everyone, and welcome to the Centralina webinar series. And today we are discussing power of attorney and guardianship, who is in charge. And we are very fortunate to have Marjorie Brown as our speaker with us today. Very quickly, I'm going to go over just a couple of housekeeping things to just let you know kind of any important information that you need to know about the Zoom and the Zoom webinar features. Not everyone, I know everyone in this day and age is very used to Zoom, but the Zoom webinar operates just a little differently. So first of all, important for you to realize you are automatically muted when you're in the Zoom webinar. You cannot see other participants. You will see the speakers and the hosts, but not any of the other participants. If you have questions, please ask questions via the chat box. And the session, it is important for you to know the session is being recorded today, and it will be available after today on the Centralina website. The Centralina website is listed there, and you should be probably on our email list at this point. If you've attended this webinar or any other webinar, you probably get some periodic emails from us. So that would be where you would find the Centralina website if you're not familiar with it. Today, our speaker is Marjorie Brown, as I've mentioned. Marjorie, if you don't already know her, and many of you probably do, but Marjorie is the founding attorney and current partner of Elder Law and Estate Planning Solutions of the Piedmont. She's the only attorney in the Cabarrus County area specialized as a specialist in elder law by the North Carolina State Board of Specialization. She's also a certified elder law attorney by the National Elder Law Foundation. In addition to elder law, she also provides estate planning and estate administration to residents in this area. On a more personal note, Marjorie is a longtime friend of mine, and we have been partners together working on the Cabarrus Elder Law, the Cabarrus Elder Abuse Task Force. And she has been a wealth of knowledge on that task force, and I know she's going to have great information to share with you today. I have heard Marjorie talk about this very topic many times, and I swear if I don't learn something new every single time. So I have no doubt that you will also, and we're very glad that you are here with us. So sit back, relax, and soak up all the great information that Marjorie has to share with us. I'll turn it over to you now, Marjorie.
Okay, thanks. Good morning. And since you said it's recorded, I'm happy to be on my best behavior. I put in the chat, I love questions. Lori said that she has yet to get a question, hear me not be able to answer a question. And try to stump me if that's the case. Yeah. I'm joking. I attended a conference where they actually had a session where it was called Stump the Speaker, and they wanted people to come up with questions that, maybe the speaker couldn't answer. Why would you do that? But anyway, so yeah, I've been practicing for 27 years now. Wow. Wow. Yeah, 27 years now. So I love elder law. I love my seniors, and then I love protecting my seniors. So we're going to talk today about power of attorney and guardianship and who was in charge, because there is a constant interplay between the two of these things. And I was telling them earlier that a lot of people have become interested in guardianship since the Free Britney movement. So, and I know that's not why we're all here today, but hopefully we'll all learn something. And this is the first time that I've had anybody ever advancing my slides for me. So I'm going to try and stay on top of this and remember to say next. Okay. So next. All right. So what we're doing here is we are, I think the basis of anything, everybody needs to understand the definitions. You got to understand the basis of it in order to be able to move forward from there. So for those of you who already know the basics of what these things are, it's going to be a refresher for you. Someone said there's a lot of static. I'm going to pause for a moment. Is everybody hearing static?
I hear it just fine.
Okay. Okay, so it might be their connection. Okay.
Yeah, I think so.
All right, perfect. Okay. I just want to make sure that it wasn't this connection here. All right, so as I said, for those of you who have already know the basics, it's going to be a refresher. For those of you that have not, we're going to start with these definitions. So next. So the question then is, what is a power of attorney? So power of attorney is basically, it's a document. It's a legal document where the principal grants the agent the ability to make certain decisions and do transactions on their behalf. So we've got terminology here with the principal is the person signing and the agent is the person designated. So if I were to do a power of attorney and basically grant my husband my power of attorney, I'm the principal. So since I'm the one signing the document, I'm the principal. Since I've granted it to him, he's the agent or the attorney in fact. So you'll hear the agent attorney in fact interspersed a lot when people are talking about powers of attorney. And so, for the durable power of attorneys, and we'll talk some more about that later, that's you'll find all that under 32C of the North Carolina General Statutes. And in January 2018, North Carolina, January 1st, it went into effect a Uniform Power of Attorney Act. Before that, everything was found in 32A. I tell people if you've got a full power of attorney and it has, long form things written out and it refers to 32A, you may want to contemplate going and sitting with another attorney to maybe get it redone, because 32A does not exist any longer at all. We can't find it in the general statutes any longer. They just took it out. So just keep that in mind. But the great thing about the new Power of Attorney Act is that it makes your agent a fiduciary. And what that means in North Carolina with a fiduciary and just about anywhere is that they're held to a higher standard. So, but them being held to a higher standard, they can be held criminally and civilly liable for their actions because all of their actions have to be in the best interest of the principal. So remember those things. Next. So then what types of powers of attorney are there? So there are financial and healthcare. Under the financial, you've got the durable power of attorney. So durable power of attorney exists beyond when somebody is deemed incapacitated. What makes it durable is that it's got to state in there. There's two different ways, let me phrase that. One is that it's got to state in the document that it's durable and that it exists and doesn't terminate by the incapacity of the principal. The other way is that the new statute 32C says that if it is enacted pursuant to 32C, then it's going to be durable unless the instrument says that it is terminated by the incapacity of the principal. So take a look at your powers of attorney and make sure that they don't end when somebody is deemed incompetent or incapacitated. Then there's a general. The general power of attorney, that one is the one that ends when the incapacity starts. So if you've got a general power of attorney that is not durable and the individual has an incapacity, then that's where it ends. It stops at that given point in time. Then what we have is a limited power of attorney. So for the limited power of attorney, that's for a specific purpose or a limited amount of time. So you have people who, they might be selling their house and they're not going to be in town the day of the closing. So they do a limited power of attorney for the specific purpose of someone signing those closing documents for them. Or if someone is going to be, traveling out of the country, presuming that we get to that point at some point soon, and they're going to be gone, and they need somebody who's able to possibly manage finances. And I tell parents, who have kids who are going to be studying abroad, make sure they do that, because a limited power of attorney or power of attorney, that way somebody is able to handle those finances for them. We have people who's like, okay, I'm going to do one just for 3 years. I don't know why just for 3 years, but they only want it for 3 years. Got it. Okay, it's in existence for 3 years. Hopefully nothing happens where you can't sign one after that, but for 3 years you've got one. Then we've got a springing power of attorney. So the springing power of attorney, that one comes into effect when an incapacity starts. So what you may have is somebody who has had surgery and they are on heavy duty narcotics. And it's not a good idea to sign any legal documents when you're on narcotics, really not. Because I've spoken with people who don't even remember conversations that they've had while they are on those medications. So the doctor says, okay, they can't be making any financial decisions. So just like a spring, it springs to life when that incapacity is there. But then, once that incapacity is gone, so they're off the meds, everything's fine, then it goes back dormant, just like a spring. And it's just waiting for an incapacity to potentially happen. So, but the thing that you need to know is that it's not accepted in every state. So there's some people, because before our new power of attorney statute, where the agent was not a fiduciary, and everybody was concerned that they're going to sell my house, they're going to take all my stuff, and they wouldn't do one that would potentially go into effect immediately, they would do a springing one. But again, like I said, it's not accepted in every state. Then the great thing is that, the principal is the person who gets to decide if it's going to go into effect immediately or when a springing event occurs. And we also have powers of attorney where, a lot of people will do their spouse. So it immediately goes into effect as for my spouse, but for the next person, it may be springing. It immediately goes into effect for my spouse as long as we're married. If we're no longer married, then that's when it stops. So there are all different ways that you can do the durable power of attorneys to basically get what it is that you need in life. So then the next one is the healthcare power of attorney. So the healthcare power of attorney is one where you're naming somebody to make healthcare decisions for you. That one only goes into effect when the doctor says the person cannot make healthcare decisions. So it's like the springing power of attorney for finances, because that one can go into effect and go dormant again. Somebody is unconscious, there's an accident, their healthcare agent can step in and make decisions for them. But then when everything is fine, it goes back dormant again. Next. So what is the process of getting this power of attorney taken care of, done or executed? So with the durable power of attorney, you've got a short form that's in the North Carolina General Statutes. And a lot of people are like, oh, I'll just pull that one out and you initial next to each line that says they can do banking transactions. They can do, I myself like the long form because then we can draft it specifically to your needs. We can say for my spouse, as long as we're married, we can say, this limited amount of time or for this specific purpose or those type of things. But that one, I just found out when doing research with this that a nursing home was sanctioned by the state bar because they had given a blank one to a resident and they considered that one as the unauthorized practice of law. Didn't know that until I was researching this. So, if that's the issue that you need to keep an eye on, a lot of people will try and draft these themselves. I had someone came in and they had pulled one from the internet and it was a California one. Well, we're in North Carolina, that one won't really work here. And they'd never been to California. It was just one they found. So you just have to be careful with those things. But also the power of attorney must be signed by the principal or in the principal's conscious presence of another that they directed to sign. And it has to be acknowledged. So what does that mean? It has to be notarized. The notary is the person who has the authority to do the acknowledgement. But how does a principal direct somebody else to sign for them? Well, let's say, for example, that you have somebody who had a stroke and can no longer, write. Because usually if somebody can just make a mark, even an X, that's sufficient. It's in front of the notary, they've shown their ID, and we just say they made their mark. But if they are not able to do that at all, then they can direct somebody else to sign for them. Can't be a family member. And you're gonna have extra witnesses on hand because it takes more steps in order to do that. But there are multiple ways in order to get this document signed for them. Next. So then the healthcare power of attorney, that one is fairly straightforward. You gotta be 18. You have to understand what you're doing. You can, make and communicate healthcare decisions. That one has to be witnessed by two people who are unrelated to the principal. And it has to be notarized. I find it interesting that in North Carolina, your power of attorney, where it gives somebody the ability to, sell the house, doesn't have to be witnessed, but the healthcare decisions does, that one does. But what we discovered also is that there are other states that require their power of attorneys to be witnessed. So in this transient nature that we tend to have, what we recommend is that you ask that your power of attorney be witnessed. That way, if you go to another state, then you've got the witnesses and you've got the notary. And that way you may not have to redo your power of attorney again. Next. I'm getting good with the next. All right. So then we're gonna move our way down to incompetency and guardianships. So incompetency, the definition is in the general statute. I think it's very, very broad. And I think they're trying to make sure they get everything, every possibility, but anyway, I'm gonna read it to you verbatim. So it's an adult or an emancipated minor who lacks sufficient capacity to manage the adult's own affairs or to make or communicate important decisions concerning the adult's person, family, or property, whether the lack of capacity is due to mental illness, intellectual disability, epilepsy, cerebral palsy, autism, inebriety, senility, disease, injury, or similar cause or condition. I think they tried to get everything possible in there. But that laundry list pulls in things that I don't believe are necessary. But that's a whole nother matter for the General Assembly for a whole nother day. But what we're going to focus here on is the word capacity, where it says who lacks sufficient capacity. So next, please. So capacity here, we've got the definition. So it's the ability to understand the information, retain the information relevant to the decision, use the information in making the decision, consider the benefits, detriments, and consequences, and then communicate the decision. So let's take a look at healthcare decisions. Are they able to consider the benefits or consequences of taking a medication or not taking a medication, or having a medical procedure or not having a medical procedure? Can they understand that? Can they consider and understand the consequences if they do or don't, do these things? Can they understand, and are they able to use that understanding in order to communicate their decision? Same thing with the financial and with the durable power of attorney. Can they understand? They don't have to understand how financial and do like a spreadsheet. They don't have to be able to do that. Do they understand that they have assets out there, that they have bank accounts? And that those bank accounts are used to pay bills, and what bills are. And what happens if you don't pay the bills? And what happens if you give all your money away? You know, so there's some basic things that they need to be able to understand, and then communicate that decision that, yes, this is what I want to do. I want to sign this document. I understand it, and I want to sign this document. The healthcare one is at a higher standard than the financial, believe it or not, because there are so many other consequences regarding healthcare decisions than there are, I guess, the financial decisions that you need to be able to take into consideration. So there are a lot of times that somebody is able to do a financial power of attorney because they understand money, they understand bills, they understand this, but they can't understand that if they don't go and have, I don't know, pick some medical procedure and the consequences of not doing that. Next. So in my world of elder law, capacity is fluid. So when I say that it's fluid, it means that you can have good times a day and bad times a day. It can be decision specific. So for us, if somebody is completely clear at 7 o'clock in the morning and the family says, we're trying to talk to mom or dad about getting a power of attorney, but they get really confused in the afternoon. But when they get up in the morning, they are very clear. Then in our world, okay, let's meet first thing in the morning. Do I need to go out to you? Usually, as far as it being fluid, they are clear when they're in their own setting. If you bring somebody to somebody else's office, they can get more confused. But if you meet with them in their home, they, at a time of day where they're clear, we can possibly get to that point of capacity where we can get some of these documents taken care of. But sometimes we can't. But understand that just because somebody has a diagnosis of dementia or Alzheimer's, that doesn't mean they can't sign the documents. Somebody will call and say, my mom, I need to do a guardianship. And so my question is why? Well, she just called and told me that she just got diagnosed with dementia or Alzheimer's. Like, she just called you? Yeah. And how long has she been diagnosed? Well, she went to the doctor today. So she went to the doctor. She got the diagnosis. She drove herself to the doctor. Yeah, she drove herself to the doctor. Okay, she have a copay that she has to pay. I'm just going down the list of things. Yeah, she takes care of all those things. She pays her bill. We don't need a guardianship. All we need to do at this point is get some documents signed with the power of attorney and healthcare power of attorney so we can avoid this guardianship. Let's try and go down the path of the easiest path here in order to make sure that decisions are able to be made. But the biggest thing is that, you're going to presume, unless otherwise notified, that everyone has the capacity to make their own decisions, whether they are in assisted living, skilled nursing, whether they're at home. You're going to presume that they have that capacity to make their own decisions. Next. So let's say that there is no power of attorney in place and the individual no longer has capacity. So what happens then? Well, at that point, we are on what I see, is the guardianship path. So it is completely codified in the North Carolina General Statutes, step by step by step. And what has to happen in order for a guardianship to take place? Step number 1 is there's a petition before the clerk. So in guardianship matters in North Carolina, the clerk is the judge for these hearings. So the clerk of court is the judge. So you fill out all the papers. There's a guardianship capacity questionnaire. Do they have capacity to know danger? Can they communicate? It's literally a 2-page document that you're going through and answering questions. Okay. So you take that down to the courthouse and you file it. So next step on that is that individual, so you're the petitioner, the person you're trying to have adjudicated is called the respondent. So the respondent has a right to counsel or guardian ad litem. So if they already have an attorney, which most times they don't, then what happens then is that they're appointed a guardian ad litem. And a guardian ad litem in North Carolina, or GAL, is an attorney. So it is somebody who understands, as an attorney, can practice law, and can help them. Their job is to meet with them. They have to meet with them, and they have to come back to the court and give a report as to what is in the best interest. They could come back and say, this person is fine. They don't need a guardianship. They could come back and say, yeah, this is a good idea. I think this person is in need of a guardianship. So then notice. So on this paperwork, you've got to notice family. So we don't go all the way out to second cousin twice removed, we do immediate family. And we notify them that there is going to be a hearing, and it's going to be on this date, and that their loved one is going to be adjudicated, whether they're competent or not. That way they can participate in the hearing and be there if they want to. There is service and notice of the petition to the respondent. And that's the scariest part of all of this, as I tell families when they're meeting with me, because the sheriff is the individual who comes and serves this document upon them. And for a lot of times, they can get very scared about, why in the world is a sheriff coming to me? Did I do something wrong? Did I do something wrong? Yes, there are fees for this. It's not free. $120 to file a petition. Some counties, they charge you in order to have the sheriff serve the documents. It just depends upon county specific. Okay. Believe it or not, as we keep on going down this path, the individual, the respondent, has a right to a jury. They could say, I want a jury trial. They have that right. At that point in time, it changes the whole aspect of things, but they have that right. Multidisciplinary evaluation. That's an option. And what that is that you have, whether it is psychiatry, neurology, social work, you have all these different disciplines who meet with this individual, and they do a report themselves as to whether or not this person has a capacity. Then we get to the hearing. So the hearing, a lot of people get confused at times, because it doesn't have to be in the huge courtroom that people think about. It can be in a conference room. It could be in a smaller courtroom. It could be in a large courtroom if there's a lot of people involved. Because when you get to guardianships, and believe it or not, if there's a lot of money involved, you've got more people who are going to be involved in this whole thing. And so you've got the hearing. It's got a process and a procedure. We've got to make sure that this is the right state that this hearing is being held in. We've got laws in place that, we had the Parental Kidnapping Prevention Act, where parents would take a kid and bring him across the border in order to get an adjudication, or so they can get guardianship of their child. Well, we've got the same thing for guardianship of adults as well. So they've got to be a resident of the state. Are we in the right county? Did we notify everybody that was supposed to be notified? We have to make sure all of these things are in place. And then the hearing is not just a rubber stamp. All right, you know what? They're here, they're adjudicated. No, there's, again, like I said, we can have the multidisciplinary evaluation. We have medical evidence that's presented from the doctors who are saying whether they are or are not incompetent. So there's a lot of evidence. Then you're asking questions. You're asking questions of the petitioner. You're asking questions of the respondent if they're there. They have a right to be there. Sometimes they don't want to. And we can't make them come if they don't want to. They say, I'm not going. Okay, well, these are your rights. We would like you to be there, but they don't have to at all. And so after we've gone through all of this, and based upon the evidence that's presented, then there is an adjudication order as to whether or not they are competent or whether they are not. Next. So then, this is actually a two-part hearing, or a bifurcated hearing is what we call it. The first part of the hearing is whether or not they are competent or not. because if they're found competent, we don't need to go to the second part. If they are found incompetent, then we go to the second part of the hearing where the clerk or the judge in this instance appoints the guardian. So at that point, what type of guardian are we talking about? Are we talking about a limited guardianship where the ward retains some limited rights? Are we talking about a guardian of the estate, a guardian of the person, or a general guardian? So there's different options and different things that can be done as far as that point goes on. So next, and I'll go into the definitions of the guardian. So what we have here is we've got a guardian of the person, which could be one person, a guardian of the estate, which could be another person, or at the top of the screen, you see a general guardian. That's where you've got one person doing both jobs. So sometimes you'll have a spouse who is the guardian for their spouse, and they may be the general guardian because they're making all the decisions. Sometimes you have it broken into different parties. Sometimes you only need one type of guardian. So the guardian of the person is the individual who is it says the care, custody, and control of the person under the guardianship or the ward. I'm going to use the word ward in this one. We're trying to move towards person under a guardianship because it is not as doesn't sound as bad. I'll just put it that way. But for me to say person under guardianship over and over and over again, I'm just going to say ward for this one. So forgive me if this offends anyone. But the guardian of the person, their job is to make sure that they are safe. They make the healthcare decisions, they make the residential decisions, mental health decisions, social decisions, and it can be family. And it can also be a corporate guardian, if there's no family. So it just depends upon, it could be Department of Social Services if they're a ward of the state. So it just depends upon who is the best person for that job. And then we get to the guardian of the estate. The guardian of the estate, that's where I usually serve. That's where you're managing the property, estate, and business affairs of the individual, of the ward. You handle legal affairs, their property, their investments, their bank accounts. Our job as the guardian of the estate is to not put the money into a bank earning 0.2%. Our job is to try to make money under a prudent person standard with their money, because these are the funds that are used to pay for their care. And so the goal is to try to generate funds in order to help them. Next. So then the general guardian or the guardian of the estate, they don't just get to, go run and fly free with an individual's funds. What they have to do is they have to be bonded. So the bond is for at least 125% of the ward's personal property, rents and profits. So when we say 125%, I have to do easy numbers right now because I'm still working on this cup of coffee. So if their personal property, rents and profits is $100,000, then the bond is going to be for $125,000. So no, you're not expected to come up with $125,000 for the bond. It's whatever the bond company requires. The minimum bond in North Carolina is $20,000. So if they have $10,000 worth of personal property, you're still going to have to get a $20,000 bond. And a $20,000 bond is usually about $120, between $120 and $150, depending upon your bond company. What does that bond do? It protects the estate of the ward from theft and misappropriation. Because as the guardian of the estate or the general guardian, we are fiduciary, okay? Can be held liable if we misappropriate funds. Our job is to make sure that those funds are there and are used for that individual's benefit. Next. So then, power of attorney versus guardianship. So here what we've got is the power of attorney. It's a power granted by the principal. You need to have witnesses for the healthcare power of attorney. It can be revoked by the principal. It can be revoked by the guardian under the general statutes that we have now. So the guardian can revoke a power of attorney. Actually, the court can revoke a healthcare power of attorney if there's a guardianship in place. And the decisions are limited to the powers that the document confers and the North Carolina General Statute. Moving over to the guardianship side, that's a court proceeding. So you've got the court costs. Like I said, $120 to file, possible cost to have the sheriff send the notice or deliver the notice, potential legal fees if you have to hire an attorney. There's a bond requirement. The annual filing. The annual filing is where you show the court with copies of checks, invoices, and receipts that all of the money that was spent in the year for that report was for the sole benefit of the ward. And this has to balance down to the penny. If you're a penny off, they won't take it. Go back, find that penny. The courts here, they know me because I come with binders and I've got it all set in there because, again, you have to have the copies of the checks. You have to have the copies of the receipts. You have to have the copies of the invoices. You no longer deal in cash when you've got a guardianship because you can't track cash. It's not even possible to report cash because you can't say what happened to it. While the power of attorney can be revoked by the principal, under the guardianship, the respondent can file a petition to have their competency restored. So a lot of times we'll see this, and I will say usually it's in the younger population where we've got a mental illness going on and they've received treatment. And so now they can have their competency restored. Sometimes, and I feel that this might be an upcoming possibility, is where you've got medication mismanagement of a senior and they cannot function on their own, but once they get their medications managed, that everything is fine, that you may be seeing some seniors coming in to have their competency restored. But for guardianships, all the decisions are limited by the North Carolina General Statute 35A. So for that, under the guardianship of the estate, if you want to sell personal property of the ward in 1 year, and the value of that property is greater than $5,000, you have to ask the court's permission. If you want to sell a house that is owned by the ward, you're generating funds for their care and concern. If you want to sell a house, you have to get the court's permission. And that's a completely separate hearing. So now we've got another filing fee. So there's another $120 filing fee for that. So it's not just you can just do whatever you want to. You need to ask permission in order to be able to continue doing some things. I actually had to file in one county because the individual had an ongoing just automatic withdrawals to their grandkids' 529 plan. And so we had to ask permission for that to continue because the money wasn't going for their care. Just so, whole point is their care. All right, next. So we're going to personalize a little bit here and start to go down some case studies, the best way I can say it. Are there any questions? I just saw down there was like 2 of them, and I just don't know what they were before I start down this path.
Marjorie, I know one question that was asked earlier was whether a social worker is often involved on the multidisciplinary evaluation.
They can be. So when you ask for an MDE, then the court usually sets all that up. And so I think they may go, if there's not a private one, if the person can't afford a private one, I'm not sure if they go through Monarch or who does it. But it's the court who sets that up, usually, if they can't afford to pay for it on their own.
We have two additional questions.
Mhm.
The next one's from Nancy Hogan. What if the guardian cannot afford the $20,000 or more bond?
So if the guardian can't afford the $20,000 bond, because you usually understand that first bond comes out of the guardian's pocket. After that, and they usually can get reimbursed. After that, that's paid by the ward because it's their insurance policy. So, but if you can't afford it, and understand with the bonding, they do the background check, the criminal check, they do all of that. If you can't afford it, then they're going to have to find somebody else to be the guardian who could afford it. That's the best way that's all I can say to that one.
Okay, next question from Charity Elliott. Is it a best practice in a long-term care facility to have physician letter on the medical record that states that the individual is unable to make healthcare and financial decisions for someone who lacks capacity?
Well, you jumped all the way down to one of my slides. So yes, yes, it is, because you need to have that information. You need to actually have that information on hand, because how do you know who's supposed to be answering those questions? I don't know what slide it is, so I can't tell you to jump to it. But for that, it's a matter of, even with the guardianship, because if the court or the guardian, if we've got a guardianship in place, has revoked that healthcare power of attorney and the durable power of attorney, then you need to know that as well.
Okay, next question. And this is from Bridget Stubbs. And it says, can you repeat revocation of power of attorney and healthcare power of attorney by guardians?
Yeah. So the guardian has the right in the general statute to revoke a durable power of attorney. So all they have to do is they're going to have to file it to put everybody on notice that it's been revoked, even if it hasn't been filed to begin with. And then they have to send notice to that agent that their power of attorney has been revoked. So they can revoke that power of attorney. With the healthcare power of attorney, that has to be done by the court. So either it can be done during the hearing, saying we're also revoking this as well, or if we find that the healthcare agent may not be making the best decisions, then the guardian can petition the court to have it revoked.
Thank you. And the last one I see for right now is from Patty Bullock. And the question is, if you have no legal documents in place, who is given legal rights to decisions?
We're about to address that. So we're about to go down that path when we start talking about who's in charge. Okay, so I've got up here, we're personalizing. I like telling stories. Lori knows that. I find that it's really easy to remember things if you personalize it. Okay, so I've got Meet Morgan and Alex. You can pick two people up here if you want to, or you can think of somebody that you know and use that name if you want to. And as we go through this, so next. Okay, there we go. So Morgan has signed a power of attorney and a healthcare power of attorney. So who's going to make their healthcare decisions? Is it going to be Morgan, or is it going to be who? So next, please. So actually, this should say Morgan versus durable power of attorney versus guardian. Okay, is what it actually should say. So if Morgan has not been adjudicated incompetent by the state of North Carolina, Morgan's making their decisions. Doesn't matter that they signed a power of attorney or a healthcare power of attorney, they're still making their own decisions. Okay. If Morgan has dementia and Alzheimer's and has not been adjudicated incompetent by the state of North Carolina, Morgan is still making their own decisions. Okay. I don't want to try and do this in a way where you can go back and go like, all right, here we are. Here's the person that makes the decision. Okay. If Morgan has a springing power of attorney and the physician says that Morgan cannot make financial decisions, then the agent can. But you've got to get a physician to say that. And sometimes it's hard to get that done. I'll just be honest about that. If Morgan has been adjudicated incompetent by the state of North Carolina, then the guardian does. Because if Morgan has been adjudicated incompetent and has a power of attorney that hasn't been revoked by the guardian, then the agent does. So you've got to figure out, again, he signed a power of attorney. If it hasn't been revoked, the agent's still making those decisions. In my world, if I've been named guardian and there is a power of attorney in place, I'm going to revoke that power of attorney because I'm responsible for everything. The guardian is responsible for all the money that is spent, all the things that are sold. So if there's somebody else out there that can do something, that doesn't work well with me because I can't control the other person. I don't have a guardianship over them. So if the agent can come and sell the house without the guardianship, and I haven't been able to get the court's approval and get the judge to sign off on it, that causes a problem in my mind. Okay, if the agent can go and remove money from the bank account, that causes a problem in my mind. They shouldn't, but they shouldn't be able to. So if Morgan's been adjudicated incompetent and he doesn't have a power of attorney, then it's the guardian. If Morgan's been adjudicated incompetent and he has a power of attorney that was not revoked, the agent. If Morgan's adjudicated incompetent, has a power of attorney that was revoked, then the guardian. So there's a constant interplay with these documents that you just need to make sure that you are on top of. All right, next. Okay, so now we're going to go down to healthcare power of attorney. Again, still should say Morgan versus the healthcare power of attorney versus the guardian. I let somebody in my office talk me out of putting that up there because they said no, they didn't like the way that looked. So if Morgan has signed a healthcare power of attorney and the physician has not said that they cannot make healthcare decisions, Morgan's still making their own decision. If Morgan has dementia or Alzheimer's and the physician has not said that they cannot make healthcare decisions, then Morgan's still making those decisions. If Morgan's physician says that they cannot make healthcare decisions and they've got a healthcare agent, then that healthcare agent does. If Morgan has been adjudicated incompetent by the state of North Carolina and the clerk has not suspended the healthcare agent, then, then the healthcare agent is still making those decisions if they have not. If they've been adjudicated incompetent and the state of North Carolina has suspended the authority of the healthcare agent, then the guardian does. And I promise I'm still getting down to that question that somebody asked about if there are no documents in place. Okay, I promise. All right, we're gonna go next.
Marjorie, do you want some more questions that are having to do with the slides that have just popped up with Morgan?
Okay, sure.
Okay, you and Morgan have spurred some questions.
That's fine.
Okay, so Lisa Fullerton is asking, does the physician have to do that in writing? And does it need to be notarized or in any certain format?
Gotcha. Hi, Lisa. Yes. Yes. It does have to be in writing for any. So if it's for the durable power of attorney, the springing, it's going to have to be in writing because you got to have something that says that they can't make those healthcare decisions. And then for the healthcare power of attorney, yeah, I still say the same thing because how do we know that this person can't make those healthcare decisions any longer? In my world, we like everything to be notarized because then there's proof that the doctor actually wrote it, the doctor signed it. And so we do it in the form of affidavits where, and it just says affidavit at the top of it, but the doctor's making their statement and it's notarized. That's it.
Okay, next question is from Charity Elliott. If the individual has dementia and the physician has provided a letter explaining the individual is unable to make decisions, Is that enough information, or does it still need to go through the court?
Hold on. I'm going to click on this one. I'm pulling up the question and answer so I can read this, just so I can make sure. They have dementia. And the physician provided a letter. So I guess my question is what I'm missing here is, do they have a healthcare power of attorney? If they have a healthcare power of attorney, then that should be enough. That should be sufficient. If they provided something, again, I like it to be notarized because it's proof that they actually signed it. Okay, they have a healthcare power of attorney, then yes, that should be, if they've signed it, I like it to be notarized, then that should be sufficient. Okay. Because only reason we're going through the court usually is if we're doing a guardianship.
Okay, great.
Okay. If the person with dementia is living at home with a spouse, I'm going to close this because this is going to distract me. Okay. The last question I saw that popped up was if the person with dementia is living at home with a spouse, what documents do they need to have? Healthcare power of attorney, durable power of attorney, advanced directive, HIPAA waiver, all of those things to make sure that there's somebody that can help make those decisions. And because I'm about to go into marriage now. So what if Morgan is married? See, you all are jumping like way ahead of me. Not a problem at all. So if Morgan's married, okay, and cannot make these financial or medical decisions, then the agents that they've named under the documents are going to make these decisions. Even if it is not the spouse, the agent is making those decisions. If Morgan's married and doesn't have these documents, if they don't have a durable power of attorney, then you may need to get a guardian named. And why? Because even if you have joint bank accounts and things like that for the with the married couple, that has nothing to do with other assets. So can't do anything with a 401k, can't do anything with an IRA. They couldn't even sell the house because there's nobody to speak for Morgan. There needs to be somebody who can speak for Morgan. And if Morgan doesn't have a power of attorney and it does not have the capacity to do one any longer, then we may have to go down the guardianship path. If Morgan has the ability, has the capacity to do these documents, get them done now. The sooner the better. Okay. So, because a lot of people think that, well, there's a spouse, they're on the bank account. Like I said, no, that has absolutely nothing to do with any of the other assets that they have. If Morgan is married and doesn't have a healthcare power of attorney, so in emergency situations, the hospitals, they use the general statute, and I've got it in here, and believe it or not, that's in the medical malpractice statute as to the order of who can make decisions. So if Morgan is married, then if there's no guardian or healthcare agent, because those are the first two people up there, guardian, then healthcare agent, then the spouse is making the healthcare decisions. If Morgan has, if Morgan's spouse has predeceased him or her, then a majority of the patient's parents and children who are over 18 years old make the decision. If Morgan has outlived his parents, was never married, and had no children, then we've got a majority of the patient siblings who are at least 18 years old. If Morgan never married, outlived his parents, never had children, and outlived his siblings, we're going down a guardianship path because there's nobody who could actually make healthcare decisions for Morgan in an emergent situation. So this is where I'm going to take a pause for a moment to discuss marriages. So If you have somebody who is in a same-sex marriage, it is even more important to have these documents done, okay? Because while same-sex marriages are recognized in the United States, if you're traveling, they're not recognized in every country. So for anybody who is in a same-sex marriage, you have to make sure that you have your durable power of attorney, which names your spouse to be able to make your financial decisions. A healthcare power of attorney, which names your spouse, if you want your spouse to be making those healthcare decisions, but that names your spouse to be able to make those healthcare decisions. Because if you're in another country that does not recognize that marriage, they're gonna go to the parents for healthcare decisions, or and it won't be you. So this is just a brief aside, just to discuss this and to say, make sure that you have these documents in place. All right, next. So now we talk about Alex. So Alex has moved into an assisted living or a long-term care facility. Who's making the decisions for Alex at this point in time? Is it Alex, or the resident? And if not them, then who? So we're going down basically just about the same path, but there are a lot of misconceptions that start to happen here. So next. So you've got the resident, Alex. You've got the healthcare agent or the guardian of the person. And then you got the durable power of attorney or the guardian of the estate. So these are the three decision makers in their interplay. And we could put verses and verses in between those as well, because this is where it gets a little bit even more interesting. And I hope I answered the question of that other person, I think. All right, let's, so next, see, I forgot to say next. Okay, so what if there is a power of attorney document in place? You're gonna still presume that there is capacity to make their own decisions unless there's evidence to support otherwise. So when I say evidence, I'm talking about guardianship or physician notation saying that they don't have the capacity. Okay, so that's gonna apply to healthcare power of attorney. I'm gonna zoom because I just saw the time. You didn't give me a 5-minute warning. Okay, so then, if Alex wants to leave and there's been no adjudication, then the facility has allowed Alex to leave. Just because the person who holds the durable power of attorney, that agent, brought them there, signed the papers for them to be, admitted or moved there, that doesn't mean a thing if they haven't been adjudicated. If Alex wants to go home, Alex gets to go home. Just because they have a durable power of attorney, this does not mean that they have given up the authority and the ability to make decisions. Next, so power of attorney in place, there's no guardianship, and the resident lacks capacity. Understand, I said lacks capacity. The agent can make decisions, but the decisions have to be within the scope of the document. And there has to be evidence that they lack capacity. There has to be evidence. You just don't presume it. There's got to be evidence. Next. Resident lacks capacity. There's no guardianship and no powers of attorney in place. What happens then? Well, the facility can petition to have a guardian appointed, because understand, anybody can petition. And at that point, if all they need is a guardian of the person, then we have a guardian person. If they need guardian person and the guardian of the estate, then we appoint both. If all the finances they have coming in as Social Security or VA benefits, then let's go down the path of getting a rep payee and a VA fiduciary to manage those things. And I'm sorry that I'm speeding right now. So that next, the question somebody asked, documentation. So facilities, you need to make sure that they have the up-to-date healthcare power of attorney and the durable power of attorney. You need to make sure that your doctor has your up-to-date healthcare power of attorney. With electronic medical records, they can scan them in. Okay. If you got an advance directive, make sure they have that too. Guardians should update all decision-making documents when they occur. So just like there's some financial institutions that require you to update your paperwork every 6 months because they want to make sure nothing has changed, then you need to update that as well, in my opinion, just to make sure that they have current documents. If you revoked any powers of attorney, that needs to be in there as well. And if there's been a restoration of competency, then that needs to be in there as well. Next. Okay, so decisions in long-term care under each one. So the power of attorney, you're going to presume that they have capacity unless there's evidence. Again, there's got to be evidence, an adjudication or something from the doctor. You can't force medication on them. That's been a big issue with regards to the COVID vaccination right now, is that you can't force medicine on them. They don't want to take it. You can't make them take it. That's considered an assault in the medical world. You can't restrict visitors without a restraining order. You just can't say, oh, nope, no, the son can't visit. You got to have a restraining order. And if the principal wants to leave the facility and go home without an adjudication, you can't make them stay. Under the guardianship, you should involve the person under the guardianship of the ward in medical decisions to the extent that they understand. Don't just go in there and just, ramrod and make all these decisions. Talk to them. Still can't force medicine that they don't want. If the facility calls the guardian, you say, yep, give them the COVID vaccination, give them a flu shot. And they come in there and like, I don't want that. They can't do it. They should not do it. And if they do, and you find out, then that's a big problem right there. You can't restrict visitors without a restraining order, but you can restrict the ward from leaving with certain individuals because they are no longer deemed competent by the state. And they can't go without notifying you. But here's the biggest difference. If they want to leave the facility and go home, the guardian has the authority to say, no, you can't. You have to stay here. 11 o'clock. New laws. Okay. Next. Sorry. Came so close. New laws in place. So we've got, do I have 2 slides for new laws?
You do. I accidentally went to the second one. This is the first one now.
Okay. I got really confused for a moment. Okay, so the first one is a single protective arrangement or transactional approval and guardianship. So in the past, if you needed to, basically, if somebody got a settlement or these payments that have been coming in, you have to create a guardian of the estate in order to manage these things. And it made no sense to create a full guardian of the estate for like a one-time transaction. It made absolutely no sense. So what they have now is for a single action. So you need to create a trust for a minor or an incompetent adult. And they have no guardian of the estate in place. Well, you can have this in place so that if they get a settlement or cash or something like that, you can transfer those funds in there. They inherited real property. It'll be able to sell that. Medicaid spend down. So they've got this in the law now. It went into effect October 1, where we can do a single action guardianship. Go in there, take care of that one thing, and then we're done. The only issue is that there's no form for it yet. So we're having to kind of, until the AOC comes up with forms for this, we're just kind of winging it as far as what we're putting in the petition about what we need to do. So it's still kind of in a weird world right now, but that's out there. And then next. And then the next one is the No Patient Left Alone Act. That one went into effect November 1. It applies to hospitals, nursing homes, hospice care facilities, adult care homes, special care units, residential treatment facilities. Because of COVID, and we saw so much of our seniors not being able to have anybody come in and visit them, and such drastic changes in them from the last time you saw them to a year later, we now have the No Patient Left Alone Act. You are entitled to compassionate care visits. I like the last one, but one of the last ones. But if they used to talk and interact with each other, with other people, and they're seldomly speaking, and they're starting to be withdrawn, you get to go visit. If they needed queuing to eat, you get to come in. If they're grieving from the loss of another family member or a friend, you get to go in. Okay. If they need family support, if they're having issues with the change of environment, you get to go in. And of course, there's end of life situations. $500 fine every time they don't let somebody in. So that one went into effect November 1. So I blew through the last few slides because I just saw the time. What are the last questions? And I will, because I know we're over.
First question from Sandra Miller. If you are not married and your mate has sisters, what happens?
You need to have a power of attorney and a healthcare power of attorney in place, because if you are not married, then the sisters will be able to make the healthcare decisions. And nobody's there to make any financial. So you need to make sure you have those documents in place. And if it's too late to get those documents in place, you need a guardianship. Then as far as who becomes a guardian, the court takes into consideration the fact that I'm guessing you two may have been living together. I'm not sure. They take into those considerations about who's the best person.
Next question, do biological and stepchildren have the same authority for decision-making if no documents exist?
No, stepchildren do not. Stepchildren are not considered their child. And for that, you really need a healthcare power of attorney, and you need to have some final disposition paperwork in place to make sure that somebody, if this individual outlives their children and there are only stepchildren left, when they pass, we need to have somebody who can claim the body. And stepchildren aren't children. So we need to make sure that they are on some document somewhere to be able to claim. So we make sure when there's a blended family, we need to make sure that there's people on each side.
Okay, next question. Even if they have an established relationship with someone they have lived with for the past 10 years, thought a good friend or someone with the established relationship could make medical decisions.
So the very last on that emergency situation, that malpractice one, it says a close friend, but they've got to get through family. They've got to get through spouse. They've got to get through if there's any parents or siblings or children. They've got to get through all these people before they get to an interested person. So always get the documents if you can.
How much weight does the BIMS score have in determining competency in long-term care?
It is, so any of the competency tests, whether it is the mini mental or the MOCA or anything else like that, that is used as evidence in a hearing for guardianship. So if somebody says, okay, they've got a very low score and they're using that as a reason why a guardian needs to be appointed, then that's used as evidence. If they've got a high score and they're using it, in evidence and for guardianship, they're going to take that into consideration of like, wait, the high score is a 25, they've got a 24 or 23. No, we're not there yet. So it can be used for evidence.
Next question, when will the recording be posted so I can rewatch? Excellent presentation and a lot to digest. Caitlin, do you have an idea on that one?
By next Wednesday.
By next Wednesday. And I know we also had a lot of questions about getting a copy of the PowerPoint. Can we send that out to folks?
Yeah.
Okay, great. So we are going to be able to send that out. That's great. Where can I review the practicing law without a license citation you mentioned earlier?
I'm going to have to, you stumped me. Okay, you stumped me. I'm going to have to look that up because I saw that in a blog for the North Carolina Bar, and I was trying to find that so that I could have that. But I'm going to have to go literally back through the state bar letters of caution and citations in order to find that, because I did not realize that had happened until I saw that there. So I'll have to find that.
Okay, so Bridget Stubbs, you stumped her, you get the prize. Yeah. And if you want to contact me later, I can get you that answer through Marjorie if you would like. Can visitors visit assisted living nursing residents, or does it apply to family, not friends.
So you're talking about in the No Person Left Behind Act. Who does it apply to? You're gonna have to contact Lori. That's two of them because this is brand new. And so literally went into effect a month and a few days ago. So it talks about compassionate care visits, but I need to go back and see. Actually,
Everything I've heard in the literature about visits in long-term care from the ombudsman position, I can tell you that volunteers do not have that right to go in and visit at this point,
okay.
if that helps him.
I was trying
And
to.
we had somebody else comment that the resident is allowed to choose one designated person. So Bridget, thank you for putting that in there. So if an individual doesn't have family, they're allowed to pick a friend to come in and visit them, or a loved, someone.
Okay.
I think that's it. Everybody else is mentioning copy of the PowerPoint.
And just so everybody knows, it'll be on the Central Line Aging website. I'll put the PowerPoint and the recording of the presentation on there.
Okay, so we can close out the question and answers and be respectful of everybody's time.
Yeah.
All right. Marjorie, thank you very much for being here with us today.
You're welcome. Sorry I ran over. I was not watching the time.
Most people stayed on. It was an interesting topic. I think people had a lot of questions, so that's great. So thank you, everybody, for coming today.
Well, it was wonderful speaking with everybody, and everybody have a good day. Stay safe.
Thank you. And we have another webinar coming up next month, right, Caitlin?
Correct, we do. And you guys will all get an invitation to that one as well, but it'll be on mental health.
Oh, wonderful. I'll sign up for that one to watch.
Thank you again, Marjorie, and thank you everyone for joining us today. We appreciate it. Hope everyone enjoys a great holiday season.